On May 17, 1954, the U.S. Supreme Court ruled unanimously that racial segregation in public schools violated the 14th Amendment to the Constitution, which says that no state may deny equal protection of the law to any person within its jurisdiction. The 1954 decision declared that separate educational facilities were inherently unequal. Following a series of Supreme Court cases argued between 1938 and 1950 that chipped away at legalized segregation, Brown v. Board of Education of Topeka reversed an earlier Supreme Court ruling, Plessy v. Ferguson from 1896, that permitted separate but equal public facilities. The 1954 decision was limited to public schools, but it was believed to imply that segregation was not permissible in other public facilities. The key phrase in the ruling was delivered by Chief Justice Earl Warren as follows: segregation of white and colored children in public schools has a detrimental effect on the colored children. The impact is greater when it has the sanction of law, for the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. A sense of inferiority affects the motivation of a child to learn. Segregation within the sanction of law, therefore, has a tendency to retard the educational and mental development of Negro children and to deprive them of some of the benefits they would receive in a racially integrated school system. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Brown v. Board received its name from the lawsuit brought by the parents of 8-year-old Linda Brown, who had to travel a great distance to attend grade school, while white children went to school a few blocks away. The NAACP brought suit on behalf of her parents to admit her to her neighborhood school. The Brown case was one of total 5 cases challenging that segregation in education was a violation of the equal protection under the Laws Clause of the 14th Amendment. They included Briggs v. Elliott, South Carolina, and Davis v. County School Board of Prince Edward County, Virginia, Gerbhardt et al. V. Benton, Delaware, and Balling v. Sharp, District of Columbia. 4 of the cases were brought by the National Association for the Advancement of Colored People, NAACP, and were argued before the Supreme Court by Thurgood Marshall. Marshall would later become the first black justice on the Supreme Court.